Hello everyone, good evening. Welcome to the event by Indian Lawyers Association brought to us by the Madurai chapter of ILA. The event is on alternative dispute resolution. Before we begin, myself Madhura, let me introduce all of you to ILA. So Indian Lawyers Association is an organization, pan-India organization with about 75 chapters all over the country. And we host different kinds of events, webinars and trainings for lawyers and all kind of legal professionals. We have several initiatives like mentoring young lawyers and law students, or the legal aid initiative, which especially picked up during the pandemic. We have ILSA, Indian Law Students Association as well, which is a subset of ILA that undertakes a lot of activities for law students. So the common vision of ILA especially is to create a voice of all the lawyers across India. And this platform has been giving local flavor to all the chapters by way of bringing people together from different cities. Here is a list of chapters that we currently have. If you are attending this event and if you do not see a city name that you reside in, please reach out to us. We would be happy to start a chapter in your city, or you could even join the chapter that is already existing. Before we begin, let me briefly introduce our speakers for the day. Mr. Suetan GS primarily has his practice in arbitration and mediation, taking up the roles of tribunal secretary, mediator, counsel, and even as an arbitrator. He began his effective practice while still being in his penultimate year of his undergraduation in law. He is now a practicing advocate in civil, criminal, and specifically arbitration-related matters in the Madras High Court and subordinate courts. He has been accredited as an associate in AIADR, KFCRI, and as a young member in CIARB and numerous other institutions. He is also impaneled as an international mediator by ADR ODR International UK. Welcome, Mr. Suvetan. Our next speaker is Mr. Shahrukh, is an advocate from Chennai practicing in the Madras High Court. He specializes in alternative dispute resolution, focusing predominantly on commercial and non-commercial arbitration. Shahrukh Kumar graduated from the School of Excellence in Law, Tamil Nadu, Dr. Ambedkar Law University. He had completed his postgraduate diploma in alternative dispute resolution from Nalsar University of Law, Hyderabad, emerging as one of the top scorers of the batch of 2020-21. Shahrukh Kumar inducted his career in the dispute resolution as a part-time tribunal secretary and dispute resolution professional. He had assisted numerous arbitral tribunals in various arbitration cases as a tribunal secretary on complete and partial service basis. He has appeared as a counsel before arbitral tribunals representing a plethora of diversified clients. Welcome for the session. Thank you for joining us. The third speaker we have for the day is Mr. Shanmuga Dev, who was educated at the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. He is a practicing advocate in India, having enrolled in the Bar Council of Tamil Nadu and Puducherry, and has considerable experience in dispute resolution. He is one of the managing committee members of Covis Foundation Conflict Resolution International, which is an ADR institution based out in Chennai. He is also a semi-qualified chartered accountant with a strong background on company law, taxation law, and other commercial laws. He regularly appears at the High Court of Madras, district courts, and several tribunals in Chennai. He is dispute resolution professional and has given opinions and consultancy for various sector-specific arbitrations. He has been accredited as arbitrator, mediator, and tribunal secretary by various regional and national arbitrator institutions. He has arbitration experience in several ad hoc and institutional commercial arbitrations and has acted as counsel in several cases. I welcome all our speakers and the participants for the day, requesting all the participants to put your questions in the chat box. End of the session, we will be answering each of the questions. Welcoming the first speaker, Mr. Suvetan.
Thank you, Madhura, for the kind introduction. Good evening to one and all present here and those who have joined us through Facebook as well. So me, Shahrukh Kumar and Shanmugadev are actually colleagues. So we have tried to divide the topic of ADR into just 45 minutes here for the sake of brevity. And I'll be taking the first 15 minutes, followed by Shahrukh Kumar and then Shanmugadev. So I will be talking about the fundamentals of ADR, and I'll give you a basic introduction on what mediation and arbitration is, and what the procedure of mediation and arbitration is presently in India. And of course, it will be continued into a perspective of the law by Shahrukh Kumar, and of course the practical aspects by Shanmugadev. So this would, of course, be very concise, and we'll rush through the seminar. And as Madhura pointed out, you can, of course, raise whatever questions you have in the chat box. We'll try to answer as much as we can at the end of the session. Thank you, everyone. So, all ADR, this the abbreviation or the acronym of ADR is Alternative Dispute Resolution. So here, the words ADR itself denotes that it is a mechanism which exists outside of the mainstream mechanism which is already in place. So in India, and of course, most of the countries in the world, that is already an existent mechanism to resolve disputes, which is called the courts. The courts of law in every country have their own mechanisms. Of course, in India, we have the CPC and the CRPC, which take up the matter into hand to resolve every dispute which arises between the citizens of the country. So ADR looks at the resolution mechanism, but takes it away from the mainstream courts of law and has it outside the courts of law. So this is the basis of ADR in itself. So in order to ADR to exist, of course, there must be a dispute. So what types of disputes can go into different ADRs is a separate topic in itself. So the terms which I'll be frequently using through my presentation here would be arbitration, mediation, conciliation, negotiation. So these words are different types of mechanisms or tools which one uses outside the court of law to resolve the dispute. So each has its own take on what the disputes can be. So for example, in arbitration, only certain types of disputes can be taken, such as commercial disputes, right? So for example, if a person is inclined to do a criminal act, and a dispute arises of that criminal act, it cannot be arbitrated. Similarly, in mediation also, certain disputes cannot be mediated. So this will be more deeply explained in the law of the respective resolutions. So I first would present that a dispute which is inclined either to mediation or arbitration or conciliation can only be taken into that particular mechanism. Second, very fundamental requirement for an alternative dispute resolution is the consensus. So, as I said, every country has its own mainstream resolution mechanism. So that is guaranteed by the constitution or the fundamental rights of every citizen in that country. So in India, I have the fundamental right to seek for redressal in the court of law. Whereas if I want to seek redressal or I want to resolve my dispute elsewhere, I need to give consent to that. So of course, a dispute cannot exist just by myself. There will be an existent another party or multiple parties. So if I want to go away, I want to waive my right of going to the court of law, not just me, along with all the parties involved in the disputes should consent to that alternative mechanism. So if I want to go into mediation, it is not that I alone should consent. The other party, for example, if me and my neighbor have a dispute, so both me and my neighbor should waive my right to go to court and therefore go into mediation. Of course, I can go to court for other reasons later in a later stage. But at that time, my consent for that resolution outside the court is required, which is very fundamental to ADR. And the second part of what is very fundamentally required in an ADR, in an alternative dispute resolution, is neutrality. So in the courts of law, again, I draw a reference there. A judge who comes and sits, you may know that person or you may not know that person. But according to our law, it is presumed that the judge is a neutral person in every case or matter which is before him. Right? So the presumption is to the fact that the judge will be neutral and is already neutral to that case. But when we go alternative, so we go to a different type of mechanism where I appoint anyone, where I have the opportunity to appoint anyone as the mediator or arbitrator or a neutral person. So at that time, neutrality of that person must concede to the parties that I am neutral of the dispute and the parties. There will be no question of bias or partiality during the course of the proceedings. So because this is done only because we're going outside the court where there exists a presumption of neutrality. The final part, which is required for required fundamental of an alternative dispute resolution, is enforceability. So the whole point, I don't want to go to court and I want to go outside towards an alternative dispute resolution mechanism, is that I will get an easier result or a faster result or a result in where I don't have to break my head for it. So when I go through that intensive process of an alternative dispute resolution, in the end, with the result product, for example, in arbitration, you get what is called an award or a judgment. So that judgment must be enforceable. So that is, if I still have to end up to go to court and the court tells that ADR is not valid at all, then the whole point of me going through an alternative resolution mechanism is moot. Therefore, the final fundamental part of an ADR to exist is the enforceability part. So, of course, as a litigant or a disputant, I would yearn for the enforceability of that resolution mechanism. So these three form the fundamental aspects of any alternative dispute resolution. So all these three have guaranteed every disputant a certain feature in all the alternative dispute resolutions. So that guaranteed feature is what is called autonomy. So the word autonomy here meaning in court, that is CPC and that is CRPC. So we do what the CPC dictates. Anyone contrary to this civil procedure code or the CPC will, the court will ensure that that is not encouraged. The court will, of course, ensure that that particular act is either dismissed or not called for. But whereas in the alternative dispute resolution mechanisms, every party is given certain autonomy in certain regions, certain parts of the procedure. For example, as I mentioned, arbitration is a procedure where we appoint an arbitrator. So this arbitrator can be anyone. So the law prescribes that the person who you appoint as an arbitrator must be a neutral person who's not involved with both the parties. So at the length, you can more describe it as a person who is more than 18 years of age and who's of sound mind. So this is the most minimal qualification you can give to any person who even enters into a contract. So at that level is the qualification given to who an arbitrator should be. Of course, I will not appoint a 90-year-old killer as an arbitrator, but that is the level of autonomy guaranteed to every citizen in India or every disputant in India who wants to go into arbitration. So this autonomy can be taken to a huge effect. So for me to go to courts, so I'm a practicing advocate. So I go through court day and night, and we have filing sections and we have court hearings throughout the day, and there are so many hardships faced there. But for example, in an arbitration hearing where I was party to it, I had the ability to go to that arbitration in a 5-star hotel. So the arbitration happened for 3 days, and all 3 days we were there from morning till evening at the same 5-star hotels. The arbitrators were staying there. We had food there. We had a good time. At the same time, the case was argued and the case was decided at the end of the 4th day. So this is the autonomy given to me to choose the venue of the arbitration and choose the mode in which the arbitration should happen. So these types of beneficial features are given only because of the fundamentals guaranteed ADR. So this pretty much sums up what ADR should be, what ADR is and what it guarantees. So before I hand it over to my colleague Shahrukh, I'll give you a brief description on how mediation happens and how arbitration happens. So thank you. So I'm given to understand that most of you are young practitioners or young lawyers. So I'll explain to you what the procedure of mediation is, or what a utopian mode of mediation and arbitration would be. So this is how it will start. So first, a mediator is to be appointed. For that person to be appointed, there is requirement of a clause. So if there is an agreement which is in dispute, that agreement must consist a clause which says any disputes arising out of this will be resolved by mediation and by appointment of a sole mediator. So or else the court itself has powers to refer certain disputes to a refer to a mediation process, wherein a mediator will be appointed by the court itself. So let's presume a mediator is appointed. The first thing the mediator does is gives the opening statement. The mediator breaks the ice. They form there's a session with both the parties, and the mediator tries to get the parties talking. So the mediator has a more of a yes, thank you. The mediator has a more of a facilitative role, where the mediator does not go ahead and argues or go ahead listens to arguments, whereas he or she facilitates both the parties to negotiate and, of course, tries to settle the dispute therein. So how that procedure happens is two ways. There are caucus sessions. So in these caucus sessions, which are either moderated or non-moderated, meaning either the mediator will be present when there is a certain issue at hand, and both the disputants try to resolve the issue, that particular issue, in front of the mediator, or if the mediator leaves the room and lets the parties negotiate and settle that particular issue. So there are different types of or different mechanisms or tools a mediator uses for that resolution. Of course, that is that I can explain to each and every one of you in a different webinar on mediation, particularly altogether. So once there is some sort of a consensus which is arrived between the parties, the mediator tries to end the session and tries to jot down the points which they have settled on. So basically, if there exists a win-win situation for both the mediators, then the both the parties, the mediator then jots down the issues and the solutions on the table and tries to make sure the parties agree on the same. Therefore comes the final part of the mediation, where the parties themselves, or with the help of the mediator, they write down the settlement agreement. So this is the end part of the mediation. If the parties agree, and if there is settlement reached between all the parties, then with the assistance of the mediator, all the parties sit and draft the settlement agreement, and they agree and sign it on. So there's a question on whether or not the mediator settlement agreement is enforceable or not. But there is new laws and new statutes coming out in the near future, so that will give more clarity on the same. So I think I'm out of time already. Okay, I have 5 more minutes. So I'll give a brief on what arbitration is and what is the basic procedure of arbitration followed in India as well. So again, similar to mediation, arbitration also requires a written agreement. So in arbitration, again, if there is a contract between multiple parties, that said contract must be having a clause or a particular provision wherein it mentions any dispute arising out of this agreement will be resolved by arbitration, wherein a sole arbitrator will be appointed. So this particular clause is required, of course, in case there is any ambiguity or there is some issue arising out of the arbitration agreement itself, then there are court-appointed arbitrations. So you take it to court, and of course, my colleague will explain more on how court will appoint an arbitrator, wherein the court or an institution. So there are, of course, arbitration institutions in India and around the world where they appoint an arbitrator. So either you and the other party get into consensus, and based on the clause which you already have in your agreement, you appoint an arbitrator, or the court or the institution appoints the arbitrator. So the first thing an arbitrator does is holds a preliminary hearing. So preliminary hearing or meeting. So wherein the parties and the counsel who represent them, or the authorized representatives, come in front of the arbitrator, either now, of course, physically or virtually, and then introduce themselves, and they file what is called an authorization letter. So which authorizes either the representatives or the counsel, of course. So when they introduce themselves in the preliminary hearing, the arbitrator requests if the parties have any preliminary objections. So this is the very first stage of an arbitration. So the arbitrator, of course, should be a neutral person, as I mentioned, and there are certain laws for it as well in the Arbitration Conciliation Act of 1996. So the arbitrator discloses that he has no partiality to different subject matters of the dispute or the parties here. So if the parties feel that there is some impartiality, there is some bias in front of the arbitrator, then they raise what is called a preliminary objections. So for example, if there is unilateral appointment of an arbitrator, the party will raise a preliminary objection of what that unilateral appointment is. And of course, my colleague will explain more on what that is as well. So the arbitrator therein has to decide that preliminary objections. So the decision on the preliminary objections can be either considered as a procedural order or as an interim award also. So this decision will either say that he or she is continuing with the arbitration after taking a decision on the preliminary objection, or he is recusing himself from the tribunal after taking the decision. So the next stage after the procedural order or the interim order will be the claim statement and statement of defense. So the party who's claiming amount or a specific performance puts in a document called claim statement. Of course, this document will have the supporting documents. This particular submission will have supporting documents as well. And in reply to this, the defense also will submit a defense statement. So this is the basic, the main part of the arbitration itself. So this will say what is the stance of the claimant and what is the stance of the respondent or the defense. So of course, the defense might have a counterclaim on the claim statement. So then the defense will be given time to file a counterclaim statement, and of course the claimant will be given time for filing a rejoinder. So with this, we come to an end of the submission of the stance or the pleadings part. So pleadings, the submission part. So the next part will be oral evidence. So this is a very unique concept where many arbitrators do not prefer to have oral evidence in their arbitration proceedings itself, because most of the disputes in India are too commercial in nature and can be decided from the documents submitted thereof at all. So oral arguments, meaning in according to CPC, in our courts of law, there will be chief examination, there will be submission of proof affidavits, there will be chief examination, and then in the end cross-examination. But in most of since the Arbitration Conciliation Act does not prescribe the Evidence Act or CPC, the procedure to be followed can be anything as decided by the arbitrator and with the consent of the parties. So most of the arbitrations in India, how it goes about is the proof affidavits are still submitted of every witness, and then there is no chief examination. The proof affidavit itself will be considered as chief examination, and it will be moved on to cross. So the cross examination will occur for a number of days as scheduled by the arbitrator, and at the end of every witness of the claimant, the respondent witness are again brought in, where the only proof affidavits are submitted and only cross examination happens. There will be no chief examination of the same. So only at the end of every witness which is required, the oral arguments start, wherein the counsels of both the sides come and argue one by one. So this again, there is no procedure, there is no set rules on how this should occur. It is completely at the autonomy of the arbitrator, and of course with the consent of the parties. So I've seen where arbitrators give 9 hours to the claimant, 9 hours to the respondent. So within 9 hours, they have to complete and the 9 hours can of course span over a period of 4 days, but then it should be completed within 9 hours. And there'll be a timekeeper who takes time on how much minutes the counsel for the claimant speak and counsel for the respondent speak. And of course, there have been arguments where the senior counsel argues for days together, and the argument stage alone will be existent for 2 months or 3 months. So that is completely at the autonomy of the arbitrator with the consent of the parties. So at the end of the oral arguments, if needed, if this is of course at the discretion of the arbitral tribunal alone, the parties may be directed to file a written set of arguments, just like in courts. Once your arguments are over, you cite multiple cases in your arguments, you submit what is called a written arguments to the arbitral tribunal. So based on the documents submitted in your claim statement, the statement of defense, the rejoinder, counterclaim, oral evidence, oral arguments, and the written arguments, with all these sort of evidences before the arbitral tribunal, the arbitral tribunal therefore declares what is called an arbitral award. So this arbitral award will be equal to that of decree of the district court or a city civil court. So this will have the enforceability value of that such degree as well. So details on how an arbitral award should be and what can be arbitrated and whether an arbitral award can be challenged or cannot be challenged is of course another session in itself. I think I've taken too much of your time. I'll hand over the session to Mr. Shahrukh Kumar. Thank you for your time.
Mr. Suethan, about the questions, how do we want to address them? Like after each session or at the end of the whole event?
I think I think there's some pretty interesting questions. So we'll wait for the end of the session so we can choose out some of the questions which we can handle, and we'll just share the questions with the three of us. If that's all.
Sure.
Thank you.
Yeah. So a very good evening to one and all. First of all, my friend Shwetan has already explained you what is alternative dispute resolution, and he has also eased the job for me. He has explained you what is arbitration and how the arbitration process begins and what all are the processes involved in arbitration. So in this short span of 15 to 20 minutes given to me, I would like to address on what are all the aspects one as a lawyer can and how one can indulge in arbitration as a lawyer. So like it was explained, arbitration is yet another form of alternative dispute resolution, wherein the dispute between the parties are resolved outside the court through a neutral third party who is an arbitrator. The arbitrator may be one arbitrator, or it is an arbitral tribunal comprising of 3, 5, or 7, or any odd number of arbitrators. And the end result of an arbitration is an arbitral award, which is equivalent to that of a decree of a civil court. So we are, as of now, we are clear with this. So we are clear with what is arbitration. So when we look into how an arbitration procedure starts, like it was explained by my friend, consensus is the key. So of course, in any form of alternative dispute resolution, consensus is the key. So as we know, consensus is an agreement between the parties. So when I say consensus, this consensus is not necessarily needed to be arrived at the dispute. So when the parties arrive at a consensus on the particular subject matter of dispute, then the dispute is automatically resolved, or there is no need for a dispute resolution. So the consensus I mean here is the consent and the agreement for the way in which the dispute has to be resolved. Of course, in arbitration or mediation, conciliation, negotiation, everywhere you need a consensus between the parties on how we are going to resolve this particular dispute between yourself. So moving on to arbitration. Arbitration is one form of ADR where party autonomy is the key. So when I say party autonomy, it means that the parties to a dispute, they have the they are free to choose each and everything which is involved in arbitration. So that is where consensus plays a role in arbitration. So the parties have to arrive at a consensus between them on what is the jurisdiction, what is the number of arbitrators who are going to resolve the dispute, what is going to be the applicable law, what is the procedure for the arbitration, what is the, and even minor issues like what is the place of arbitration, what is the language of arbitration, etc. So this is where a major difference between arbitration and litigation arises. So when you approach a court of law with your dispute, you do not have the opportunity, or you do not have the party autonomy to arrive at a consensus or to choose the particular jurisdiction or the applicable law. But whereas in arbitration, you have the autonomy as a party to choose the jurisdiction. So for example, there is a concept of seat in arbitration. So the parties to a dispute may, at the time of entering into the arbitration agreement, decide on what is the seat of arbitration. So thereby they decide on what will be the appropriate jurisdiction for their dispute, which is not available in a court of law. You cannot go to an appropriate forum which you wish to resolve a dispute. You need to approach a court only which has a territorial jurisdiction or a pecuniary jurisdiction or a subject matter jurisdiction. But whereas in arbitration, you have this option of approaching a forum which you would like to choose as your jurisdiction. And coming to the procedural law, like it was already explained, we have the Code of Civil Procedure, which is determining the procedure to be followed in the courts while resolving the disputes. Whereas in arbitration, you are free to choose the procedure for resolution of a dispute. So in a court of law, you cannot go against the Code of Civil Procedure, and you cannot frame your own procedure for resolving the disputes. Whereas in arbitration, you have this autonomy. if your opponent, that is, if the parties to the dispute arrive at a consensus, then you have this opportunity to decide on what is the procedure of arbitration. You can decide that it is going to be only a document only arbitration where there is no oral pleadings, or and the dispute is resolved only through written arguments and things like that. And the number of arbitrators. When you go to a court, you cannot decide on who is going to be the judge or what is going to be the quorum of the bench which is going to determine your dispute. Whereas at the time of entering into an arbitration agreement, the parties have the ability, or they are free to choose on the number of arbitrators, and they can even, at the time of appointing an arbitrator, they have the freedom to choose who is going to be the arbitrator. And that is what makes arbitration quite different from any other form of dispute resolution and from the mainstream litigation. So again, like I said, I want to explain certain aspects of the law of arbitration, which would be the fundamentals of initiating an arbitration and conducting the arbitration proceedings. So before that, we need to understand that there are two types of arbitration. One is ad hoc arbitration, and the other is institutional arbitration. So ad hoc arbitration is one wherein the arbitration is conducted by the consensus of the parties without resorting to any other third-party institution, arbitration institution or ADR institution. So the parties, they themselves appoint the arbitrator, they decide the procedure for conducting the arbitration, and the arbitration is conducted. Whereas in institutional arbitration, you resort to a neutral third-party institution which takes up the case. So let's assume like this: the institution is going to be the court of law, but it is not a statutory authority. It is not a court, but it will take up all the role of the court. It will have a registry for itself. It will appoint the arbitrator, and it will be with you till the award is passed. This is the fundamental difference between ad hoc arbitration and institutional arbitration. So to my knowledge, arbitrations can be invoked in three ways. In India, I'm speaking from the perspective, Indian perspective. So in India, arbitrations can be invoked in three ways. So the first is by the consensus of the parties, which we have already discussed. So as we know, a contract or an agreement is the basis for any dispute. So at the time of entering into the contract itself, you can decide that whenever any dispute arises out of this contract, it can be resolved through arbitration. This is by the consensus of the parties. Or even after the dispute has arisen, you are free to choose that arbitration will be the forum or the mode in which the dispute is going to be resolved. The second form in which arbitration can be invoked is that the dispute has already arisen and you have approached, and one of the parties has approached the court, either by way of a suit or etc. So after one of the parties has approached the court, the other party has the right, and let's assume that there is an arbitration clause in this particular dispute. So out of you go with the dispute out of a contract, and that particular contract has an arbitration clause, and one of the parties has approached the court of law. The other party has the right to tell the court that there is an existing valid arbitration clause with regard to this particular dispute, and therefore this dispute can be arbitrated. So that court has the power to refer this dispute to arbitration. This is another way in which arbitration can be invoked. And the third way is by way of Section 89 of the Code of Civil Procedure. So Section 89 of CPC is settlement of disputes outside the court. So wherever any court of law finds that a particular dispute before it can be settled or resolved outside the court, it can refer that particular dispute either to arbitration or mediation or conciliation or even lok adalat. So these are the three ways in which arbitration can be invoked in India. Now, coming on to the law of arbitration in India, Arbitration and Conciliation Act 1996 is the law governing arbitration in India. So it is basically the procedural law. So what we have to understand here is arbitrations are not bound by the Code of Civil Procedure or the Evidence Act 1872. So the Arbitration and Conciliation Act is the procedural law which governs the arbitration in case of an ad hoc arbitration. And where it is an institutional arbitration, the institutional rules will govern this arbitration procedure. So there is no role of the Code of Civil Procedure or the Evidence Act in an arbitration proceeding. So our Arbitration and Conciliation Act 1996 was basically an extract of the UN Citral Model Law. So the United Nations Commission on International Trade, it wanted to adopt a model law on arbitration. And our arbitration, and prior to this Arbitration and Conciliation Act 1996, we had the Arbitration Act 1940, which cannot be compared with the present day arbitration scenario. So we'll keep it aside for a discussion in a different day. Coming to the Arbitration and Conciliation Act of 1996, there are certain key aspects which I would like to highlight, which would be useful as a lawyer who is starting his practice in arbitration. So starting off with Section 7, an arbitration agreement. So my friend has already explained what is an arbitration agreement. One key point I would like to highlight here is an arbitration agreement can be, there is no mandatory procedure, there is no mandatory form of an arbitration clause. The Arbitration and Conciliation Act does not say that an arbitration clause must be in this form. It says that it must be in writing. But even the mere use of a word arbitrator or arbitrate in itself can constitute an arbitration clause. So what is to be considered here is the particular court which decides if there is an existing arbitration clause will see whether there is really an intent to arbitrate between the parties. So this intent to arbitrate must be proved beyond reasonable doubt to hold that there is an existing arbitration clause. So that is what pertains to Section 7. And coming to another important section, that is Section 8. As I explained, it is the power of a court to refer the parties to arbitration. So as I said, when you have a dispute which is a subject matter of an arbitration agreement, and that particular dispute is resorted to any court of law for resolution, that particular court has the power to refer back the matter to arbitration. This power is given by virtue of Section 8 of the Arbitration and Conciliation Act. So why I am stressing on this Section 8 is that whenever you enter into any contract, or whenever any contract which is in dispute comes to you as a subject matter, the first thing you need to verify is whether it has an arbitration clause. And if that particular agreement is contested before any court of law, then you have all the right to inform the court. Of course, this is all before the submission of any written statement before that court of law. But you have every right to inform the court that there is an arbitration clause existing, and that this matter has to be adjudicated only by a competent arbitral tribunal. There are three major sections which I would like to focus pertaining to the role of courts in conducting arbitration. So one is Section 9 of the Arbitration and Conciliation Act. Section 9 pertains to interim measures which can be granted by the court in respect of arbitration matters. So let's assume that there is an arbitration clause in a particular contract, and the contract has been breached. Now you want to approach arbitration. Either before the arbitration is invoked, that is the arbitral tribunal is appointed, or during the arbitration proceedings, or even after the arbitration is completed and the award is passed, but the award is still not enforced, you have every right to approach the appropriate court for any interim measures. So what could be the interim measures is specifically stated in Section 9 of the Arbitration Conciliation Act. Due to brevity of time, I'm not able to go deep into the particular section, but Section 9 pertains to these interim measures. So why I'm stressing on this is whatever we come across cases where the property is attached even before the arbitration is commenced, or during the arbitration proceedings a property is attached, or a bank account is freeze. These are all by way of Section 9 of the Arbitration and Conciliation Act. And the other two sections that I would like to focus with respect to the role of courts is Section 11 and Section 34. So Section 11 is with regard to appointment of an arbitrator. So when the parties are not able to arrive at a consensus on who has to be appointed as an arbitrator, or the procedure for appointment of arbitrator, they can approach the appropriate high courts under section 11 for appointment of the arbitrator, and the courts have the power to appoint such arbitrators. And another section, as I said, section 34 of the Arbitration Conciliation Act, it is the section for setting aside of an arbitral award. So this is another area which I wanted to focus. So in arbitration, one major advantage is that you do not have the right of an appeal over an arbitration. So once an arbitration award is passed, it is final and binding on all the parties, all the parties to the arbitration. So you do not have the right to appeal, go on an appeal before any court over an arbitration award. The only resort against an arbitral award is to set aside the award under section 34. Again, there are certain grounds on which an award can be set aside. Like, for example, there is no valid arbitration clause, or one of the parties to the arbitration was not given a proper notice of arbitration, or if it is against the public policy of India, an award can be set aside under section 34. So now I'm running out of time. I'll just conclude in 2 minutes. So now the reason I wanted to stress on section 9 and 11 and 34 is that in India, every year, to my knowledge, there are at least 20 lakh arbitration cases invoked and conducted every year. But in these 20 lakh cases, the number of cases in which the procedure is properly adopted and the number of cases where a proper resolution is arrived is a question. So what is needed here is the common mistake I find in among litigants or among lawyers practicing an arbitration is that once we see that an arbitration has been invoked, the common stereotype advice to that is, after the arbitration proceeding is completed, anyway, one has to come to the court and let us challenge the proceedings in the court. But that is not how it is. If the spirit of the Arbitration and Conciliation Act is upheld in the right way, then definitely arbitration could be the key factor by which the disputes are resolved in India. All non-banking financial companies, they have an arbitration clause in their contracts. Whenever there is a default in the payment of loans, the dispute comes to arbitration. But the number of cases which are contested, or the number of cases in which the arbitration is conducted in the manner it should have been, is a question. So I would like to conclude by saying that as lawyers, it is our fundamental duty to uphold the spirit of Arbitration and Conciliation Act for a better dispute resolution. So I think I've exceeded my time. I would like to hand over to my friend Shanmugdev.
Thank you, Mr. Shah. And I thank Indian Lawyers Association for this great opportunity for addressing, especially the topic of the practical aspects in arbitration in India. So, due to the paucity of time, I think I have slides which could be projected so that it's all self-explanatory. I request the host to enable me to slide share it. Yeah, thank you. So, due to the paucity of time, I'll just touch upon some of the practical nuances and how it's being currently followed in India. So, the use of commercial arbitration and the recent trends is it's preferred in most the dispute resolution, which is of complex disputes, and it is becoming a standard practice for the parties to include the arbitration clauses in all large transactions and agreements. For example, all the government entities and the public sector undertakings have started including arbitration clauses in their standalone contracts, and in order to avoid the long battle litigations. So there are some of the amendments in arbitration acts, not just to say that even in the evolution of the arbitration, all these amendments have been incorporated, but still these are some of the things which is to be still worked on. One is the imposing time limits. Arbitration itself is a speedy recovery measure for litigations. So imposing time limits is still one of the needed amendment to be brought in arbitration. And encouraging institutional arbitrations, I'm pretty sure you might have understood what is institution and what is institutional arbitration all about. So as of now, there are a lot of institutional arbitration which has been mushrooming in India. I think it's time to encourage the institutional arbitrations in India. And reducing the scope of court intervention, especially both at the pre-arbitration, the post-arbitration stages, and discouraging the filing of frivolous applications, especially when it comes to the award part, that is when challenging the award. So these are some of the amendments to be brought in, to be kept in mind, especially in the future arbitration law. And I think my friend beautifully covered both the arbitration legislation, that is Arbitration and Conciliation Act 1996. The part one deals with the domestic arbitration, that is the arbitration seated in India, and part two deals with arbitration seated outside India. So just adding one here is we had an amendment in the year 2015. So all the arbitration, which is after 23rd of October 2015, is governed by this act with the 2015 amendment. And we do have an amendment which has been recently amended in the year 2019. So here are some of the mandatory legislative provisions, though it has been elaborated. I just want to bring the slides. Moreover, it's explanatory because these are some of the mandatory provisions to be kept in mind, especially in the practical nuances of arbitration in India. There is requirements for the form of the arbitration agreement, and the mandated reference to the arbitration by the courts. The grounds of ineligibility is presumed impartiality in the lack of independence of the arbitrators, and the time limits for completing the arbitration proceedings. The grounds for setting aside the award and challenging the enforcement of the arbitral award. These are some of the important provisions, the mandatory provisions the Arbitration Act contains. And a violation of these conditions, either can preclude reference to the arbitrations, or it might make the arbitration proceeding itself as invalid, or it could be a ground or result to an award being set aside by the courts. However, those those conditions, those grounds dealing with impartiality or the independence of the arbitrators has to be first challenged before the arbitrator, before you taking the ground while setting aside the award or during the process of the enforceability. These are some of the disputes which cannot be resolved through the arbitrations. This is something in today's scenario: criminal offences, matrimonial disputes, guardianship matters, insolvency petitions, of course, testamentary suits, trust disputes, labor and industrial disputes, and this tenancy and eviction matters governed by the rent control statutes. I think it's not absolute to say all this has been not governed by arbitrations. There are recent judgments, Supreme Court judgments, which say, when there is an arbitration clause in the, the agreement, which can be given a role, even though there is this special statute exists. So there is one of few judgments existing to contribute to difference this. And of course, the disputes in rem, generally this, which has been surrounding the principle called, the right in rem, that is right against the world, which cannot be actually resolved to the arbitrations, but the disputes which is, which are all against the personam, this right in personam, can be resolved to the arbitrations. This principle, which has been underlined in the landmark case of Parkinson's Eastman judgment, I think this whole judgment is based on this one of the lines which relied on the matter. So speaking of the arbitral institutions, because I think it's the 11th hour time to think about the role of arbitral institutions in India. There are a lot of institutions. The bifurcation could be international institutions such as SIAC, that is Singapore International Arbitration Center, and we have London Center of International Arbitrations, HKIC, that is Hong Kong, ICC we have. So we have a lot of international arbitrations institutions other than that. But speaking about the domestic arbitration institutions, still there are a lot of people who doesn't know the existence of a lot of domestic arbitration institutions in India. We have Kawais Foundation Conflict Resolution International, which is an area institution based out in Chennai, and we have Mumbai Center, and we have Nani Balkiwala. Apart from that, there is also High Court annexed arbitration centers. We have arbitration centers which has been annexed by Madras High Court. We have one with Bombay High Court. So there are a lot of arbitration institutions, even the mediation institution has just been court annexed. So coming to the the practical nuances governing some of the issues, the first one I will go on with jurisdictional issues. So this has been the resource could be the principle of competence and competence, which means the arbitral tribunal is empowered to decide on its own jurisdictions. That the same has been told to the provision section 16 of the Arbitration Act. So, you know, when the objection of this jurisdiction can be governed before the arbitral tribunal is you have a time limit, especially that is before the statement of defense is being filed. So till that you can, challenge the jurisdictional aspect, jurisdictional issue before the tribunal. However, it is the discretion of the arbitrator or the tribunal to rule on the jurisdiction, but still you can take this ground even if it comes against your issues during the challenge of the arbitral award. So some of the arbitration agreements validity requirements is when we speak about the arbitration agreement, the first provision which should strike the mind is of course the section 7 of the Arbitration Act, that is which says an arbitration agreement must be in writing, and the section 7 has a lot of sine qua nons which has been laid on that should be contained in the arbitration clause, arbitration agreement I could say for section 7, and it should be signed. It's a type error, must be contained all of the following actually. So it must be signed with all the parties, and it could be an exchange of correspondence which provides a record of the arbitration agreement, or it could be an exchange of statement of claim and defense containing an undisputed acknowledgement of the agreement. So it's just not an explicit agreement which should have an arbitration clause so that you can initiate the arbitration proceedings. Even it could be of an exchange of correspondence or exchange of statements. And a separate arbitration agreement, here I would like to give you one principle called the principle of separability, which means even the main contract, if it turns out to be void ab initio or if it's voidable, the arbitration agreement, which is more of a clause in the main contract, always has the life. That is, the arbitration agreement can either be a way of a separate agreement in the form of a clause in in a larger agreement, or can also be incorporated by way of reference to a document containing this arbitration clause or an agreement. So always what I like to stress is this arbitration clause always has a separate recognition as an agreement, even though the main contract has been turned out to be void ab initio. So third parties, this is the role of the third parties is still one of the disputing factor in a global perspective. So whether a third party can be brought in arbitration proceedings is still a question, is still disputable. There are judgments which says which creates a lot of differences actually. So, but if you analyze the provision which says that when a person claiming through or under a party to the arbitration agreement, then it gives the role to the third parties. However, the courts have not provided an exhaustive definition of who qualifies as a person claiming through or under a party to an arbitration agreement. But while interpreting the phrase, the courts have permitted the parties to be joined in an arbitration where a single commercial transaction is executed to a number of agreements involving multiple parties. So, to my knowledge, what I would stress here is that in order to bring in a third party, in order to claim under the point that is a person claiming through or under, you must have a single commercial transactions which should have been executed through a number of agreements involving multiple parties. This is something about breach of an arbitration agreement. That is court proceedings in breach of an arbitration agreement. If the court proceedings are initiated in breach of an arbitration agreement, that is, you have an arbitration clause in your contract, in your agreement, or whatever in the form of in your dispute. But if you have been referred, you have been in the litigation process, it is always the discretion, it is always the rule that it can be diverted to the arbitrations. That is, the aggrieved party can always make an application under section 8 if it's of domestic arbitration, or section 45 if it's of foreign arbitrations, requesting the court to refer the parties to the arbitrations and to entertain all the proceedings related to the arbitrations, and they can also decline the litigation process. However, if that aggrieved party or whoever wants to commence the arbitration is not making his own right in terms of application, it means that they have waived the right of referring such clause in the main contract. And this is more of a court proceedings in breach of an arbitration agreement. And arbitration breach of a valid jurisdiction clause, I think I have dealt in my earlier one of the slide, which means if you have a jurisdictional issue with the tribunal, you should challenge it before the tribunal first. And it is the discretion of the tribunal to either rule to decide whether they have the jurisdiction or not. If they have ruled against you, I think the only remedy you have at the end of the day is to go for setting aside a award under one of the ground as such that. And this is some of the procedures I think I would like to touch upon. One is local courts granting an injunctions. The Indian courts, both law and equity, have the power to issue an anti-suit or anti-arbitration injunction as well to a party or whom they have a personal jurisdictions. And the other factors which is to be governed while granting an injunctions, apart from the the essential elements of the injunctions, such as balance of inconvenience, the such factors which is to be governed by the court is the committee of courts, the mandatory language of the arbitration clause, and so on. So this is something, the procedural aspects which has been taken by the courts regarding an injunctions, not just satisfying the essentials of the injunctions, along with that also, other factors which has been taken by the courts in a long way. And number of arbitrators, it is one principle that it is always odd number of arbitrations is something followed, and it is something the practical aspect. But if you have an even number of arbitrations, during the constitution of the arbitral tribunal, it is not that it is automatically invalid. It means that if the parties do not specify the number of parties, the arbitral tribunal will constitute the other arbitrator and proceed on and go on with the proceedings. And qualification of the arbitrators till today, I mean, if you take today's law, there is no explicit qualification which has been laid down in the act saying so these are the qualifications to be so. However, the 2019 amendment, it brought out a lot of qualifications to be an arbitrator, especially relying on the basis of 10 years professional experience. However, the 2021 amendment has made it a reversal of that, and there is no qualification as such till today to say so he or she is the qualified arbitrator. And appointment of arbitrators, the arbitrators are always free to agree the procedure for the appointment of arbitrators. This actually comes under the principle of party autonomy. So the party autonomy, it is always the parties to decide on the procedure, how they want to have all their proceedings and everything. And this is, I think, this is one thing I've covered already. When they fail to nominate an arbitrator, they can always approach the court to have an appointment. And some of the applicable procedural rules is Section 19 of the Arbitration Act recognizes the right of the parties to agree on the procedural rules applicable to the arbitration proceedings, that is the party autonomy. And the scope of disclosure, I have made it in terms of the party's perspective, not in the arbitrator perspective. So it is always the parties to decide on what documents to be brought in, especially along with the 11th of the Statement of Claims and Defense. So it is always the discretion of the parties to bring in what are the documents they need to bring in. And validity of the parties, which has been dealt under Section 19 of the Act, that is, parties can agree upon, or the tribunal can decide the procedure to be followed in conducting the arbitration proceedings. This includes the right to agree on the procedure of discovery, inspection, and the production of the documents as well. So the tribunal or the party can also seek the assistance of the court for the examination of the witness and the production of the documents, which has been dealt in Section 29 of the Act. And confidentiality is one thing which is universally followed, which is one of the very significant part of the arbitrations. The proceedings is to be maintained very confidential. So these are some of the court interventions to assist the arbitrations. This is also very self-explanatory. This is some of the provisions which has been dealing with. I think this has been dealt in by the previous speaker. However, I think I'll circulate the slides so that it will be easy for you when you come across it. So apart from that, some of the other procedure I would like to highlight here is interim remedies. The arbitral tribunal is empowered to grant interim reliefs during the arbitral proceedings. What is to be noted here is it has the power to grant an interim relief until the making of an award. And ex parte, if the party fails to appear before the tribunal, despite having the notice, the arbitral tribunal can grant ex parte interim relief. And the other procedure just to be stressed on here is the security. The arbitral tribunal can grant orders to provide security for any amount, goods or property in dispute and arbitrations. So while granting such remedies, what all the different remedies they have is declarations, injunctions, payment of money, or the specific performance as well. What is to be noted here is they cannot grant a punitive damage. It's only for only have to monitor in 8 years. Right to appeal awards rendered by the arbitral tribunals are considered to be the final and binding in terms because it is the decision of the merits, and thereby, as per today's statute and as per the customary law of arbitration, there is no appeal allowed from the arbitral tribunal to the courts. However, you can challenge the arbitral award that has been dealt in Section 34. You have a time limit to challenge the award. Once they pass, you have a 3 months, and of course, you have 1 more month if the court justifies that. So you cannot go on of an appeal of an award, but you can go for challenging the arbitral award itself. So enforcement of an award, an arbitral award is enforceable. I'm dealing with domestic awards first. So an arbitral award is enforceable after the time of making an application to set aside such an award has been expired. That is 3 months. So the party intending to enforce the award can file an execution petitions before the civil court, the competent civil court. And even one more remedy you have here is if a party wishes to seek a stay on the enforcement of the award, still they have a remedy to make a separate applications in the competent court for that purpose. To touch upon the foreign awards, India is a party to both the New York Convention, the Geneva Conventions, and the execution of the foreign awards. So all the execution grounds, the nullity has been dealt, especially under the New York Conventions. So these are some of the important points to be kept in mind during the enforcement of the foreign arbitral award in the practical aspect. So an award rendered in a commercial arbitration in a gazetted convention country is enforceable in India. So what is very important here is the gazetted convention country in the conventions. So the procedural requirement for its being dealt under Section 47 of the Arbitration Act, 47, 40, 49 as well actually. So the grounds for refusing the enforcement of the foreign award are largely the same as the grounds for setting aside the New York Conventions. The New York Convention has set out some of the grounds for setting aside a foreign arbitral award. The same is being dealt in our Act as well. So one highlight is here that the domestic award can be set aside using the ground of patent illegality, which cannot be done in terms of foreign arbitral award. So, once the court is satisfied that a foreign arbitral award is enforceable, it would be deemed to be decree of the court under Section 49 of the Arbitration Act. So, it is actually the process is similar as that of a domestic award as well, actually. So, some of just like what we dealt with, some of the practical aspects which is being governed or which has played a very vital role in terms of arbitration law in India. But these are some of the changes to the law currently under consideration or it's being proposed. And I think there are a lot of presumptive points which is to be taken, maybe in the upcoming amendment as well. One could be that the expediting the appointment of arbitrators to the designated arbitral institutions and creating an independent body, that is the Arbitration Council of India, because it's still haven't it is still in the idea perspective, it's still not being floated practically. So actually this Arbitration Council of India, the role could be the grading of arbitral institutions, accrediting the arbitrators, and it also has its role for evolving policy and guidelines for the establishment of operations and the maintenance of all this uniform professional standards in arbitrations, and set standards for the qualifications of arbitrators, and maintaining an electronic depository for all the arbitral awards. So these are some of the changes to the law currently under consideration for being proposed as of now. I would like to highlight some of the recent judgments. Actually, these judgments has been, attained its finality, of course, towards the end of the year 2021. That's why I just brought 4 of the judgments here. This judgment is of Tata Capital Finance Limited versus Srishan Construction Apartment Private Limited, which actually came in the last month, at the November end. This actually dealt with the question of whether an arbitration clause that allows the arbitral proceedings to be abandoned at the will of one party would be valid in law. So the High Court of Delhi held that arbitration agreement that confers unequal power on one party to unilaterally abandon the arbitration proceedings will be invalid in law, because the main essential of mutuality is being it's been made to be absent if such amendment is made. The other judgment is Arun Srivatsava versus LNT. This came on 9th of November. Whether a party can file a writ petition against an order referring the parties to arbitration under Section 8 of the Act. The High Court of Delhi held that such petitions is not maintainable. Such writ petitions going on under Article 26, referring the parties to arbitration under Section 8 is not at all maintainable. And another important judgment which dealt with the panel of arbitrators maintained by the respondent will be hit by Section 12 is BCC Developers versus DMRC. This judgment actually relied on the judgment, the landmark judgment for Central Organization for Railway Electrifications, in which the Delhi High Court held that merely because the arbitrators or the panel or of the ex-employees of one of the parties, it would not make them ineligible to be appointed as arbitrators to decide on the dispute. So when the parties agreed on a procedure to appoint the arbitrators, the appointment shall be made in accordance with the agreed procedure only. So this is the other judgment I would like to highlight, which deals with the seat of the arbitral proceedings. There is SP Single Constructions versus this construction and design services UP. It is held that the rule of the arbitration would, institution would not determine the seat of the arbitration. The seat would be still decided in accordance with the agreement with the parties. It further held that the rules of procedural nature only and come into only play after the commencement of the arbitrations. So these are some of the judgments I would like to bring to you all, especially in the practical aspects. So I think I am to the end of my presentations. Any questions, I'll be glad to answer.
So there are a few questions, a couple of them in the chat box.
I think the 3 questions already here. So my co-speakers don't mind, we can take one each. And if there are other questions as well, of course, the participants can put it in the box. So I'll take up the question with relation to the construction claims and settlement. So that is quite an interesting question, actually, because all 3 of us have been working on construction arbitrations for quite some time now. So we have worked in arbitrations where the entire dispute of the construction arbitration will be so technical in nature that I am 100% sure High Court judge would not have, or even a Supreme Court judge with expertise in law will find numerous difficulties in deciding the technical issues. So there have been arbitrators who have been appointed, such as the retired chief engineer or retired engineer-in-chief of the civil departments of every state. So these people are experts. And I see we have another question: can non-lawyers become arbitrators? Of course, these technical or retired engineers who sit as arbitrators, I have seen in my first-hand sight, who have been experts, and they decide technical issues as in minutes, and they be on point. So that level of expertise can be seen in construction arbitrations, and resolution of construction arbitrations are done by arbitrators who are technically sound and experts in their field throughout India. I don't find most of the construction agreements which come through my office are always have an arbitration clause with them, because most of the construction disputes in India right now are resolved by technical arbitrators, or at least arbitrators who are appointed by the parties. So if Shanmugadev, you can take a question.
Yeah, I can take the questions. There's one question which asks, apart from the arbitrators and mediators appointed by the court, how the arbitrator mediator is appointed in the private arbitration and mediation center. I'm very glad to answer this question. Actually, I think my other co-speakers will also be very glad, because coming from an institution, since we are all managing an institution, ADR institutions, all KFCR, Economics Foundation, Conflict Resolution International, I think I've dealt about few minutes back. Referring and disputes to an institution arbitrations, not just that, the main essential element of the arbitration itself is the arbitration clause. So to refer in parties, to refer the disputes which is approached to the institutions, or the disputes what you have in hand, which is to be governed by the institution, you should have that specific clause, the arbitration clause, which should lay down that this dispute can be referred to so and so institution, for example, KFCR institution. And when such references be made, and when those disputes come to KFCR institution, we have our own empaneled arbitrators or the mediators as well. How we have those empaneled arbitrator mediators, such as that those are all accredited arbitrator mediators of our own institutions. They go through rigorous trainings, and they have to qualify certain exams to become such empaneled arbitrators. Not just that, there are certain competent professionals who also become empaneled arbitrator mediator based on their professional expertise or the experience. So such empaneled arbitrators mediators are all in board with us. So when such dispute come to us, it is the discretion of the parties to choose either of the arbitrators among the list we have, or we might refer. I'm saying we might refer based on the nature of the dispute. We might refer the expertise to govern such disputes. So this is how institutional arbitration, the mediation takes place actually.
Yeah, I see one question with regard to enforceability. Someone needed more clarity on enforceability. So I think my friend Shanmugadev has gone into the depth of enforceability, but again, giving more clarity to it, any alternative dispute resolution, be it arbitration or mediation or conciliation. So the end result of it, be it an arbitral award or a mediated settlement agreement or a conciliated agreement, it all has to be enforced. So as during my presentation, as I had stated, an arbitration award is equivalent to that of a decree of a civil code, and it has the enforceable nature of a civil code. And even in case of mediated settlement agreements after the UNISA, the Singapore Convention, even the mediated settlement agreements have been declared enforceable. So speaking about enforceability, it is nothing but your dispute is not resolved as soon as an award is rendered or a settlement agreement has been arrived. There is a process after that, that is enforceability. So you approach the appropriate court with your award or the agreement, wherein the court certifies the award and the court enforces the award. So this is what is with regard to enforceability. Maybe we can, I think enforceability is a vast topic. We need to have a separate session on that. But explaining the giving more clarity on that. This is what enforceability means. Any end result of any alternative dispute resolution has to be enforced by the court. It is just like the decree of any civil court has to be the same way in which it has to be enforced. So I think that's all with the questions, and we have already exceeded time. So I would like to extend my heartfelt thanks to Indian Lawyers Association for giving us all this wonderful opportunity to meet you. And thank you all the organizers who have arranged for this wonderful session. I would also thank my
to all our
speakers,
speakers.
Shwetan and Shanmugadev.
Indeed. Thanks to all our speakers. We very well understand with the limited time, the constraint of, presenting so much in a little time. So we appreciate wholeheartedly that you shared multiple aspects of alternative dispute resolution. We would be keen on doing in-depth sessions on each of the topics separately, maybe in the near future. Thank you to all our participants for joining in today. The recording is already there on ILA Facebook channel, and it would be updated to our YouTube by tomorrow. And we look forward to welcoming you at the upcoming events. The immediate one is happening on the coming Saturday, 15th of January, which is for the law students, and it would focus mainly on opportunities after studying law. So the details for this event are also on our social media as well as the website. Look forward to welcoming you for the upcoming events as well as being active at the chapters in your respective cities. Thank you so much. Have a good evening. Bye-bye.
Thank you, Madhura. Thank you, everyone.
Thank you all. Bye.